Good morning, everyone. Welcome to COVID-19, an employer's action list for employee benefit plans webinar. We're so glad to have you here today. I'm going to go ahead and wait just a few minutes to start our presentation and let all of you attendees cycle in. So I'm going to wait about another minute and then we'll get started. Okay, it looks like we still have several of you cycling in. Just going to wait another probably 10-15 seconds and then we'll get going. All right, again, welcome everyone to COVID-19, an employer's action list for employee benefit plans webinar. We are thrilled that you're joining us today. Before we get started with our presentation, I just have a few quick housekeeping items for you. Just to let you know, this webinar will be recorded, so look for an email coming out later today with a link to the recording and also links to a lot of other free content that we have for you. Our presentation will run for 50 minutes, 50, with a 10-minute Q&A following the presentation. So please make sure to type all of your questions into the Q&A box. That is going to be in your menu. So if you hover your mouse at the bottom of your screen or at the top, you'll see a little Zoom menu with a Q&A box. It looks like a little bubble. There's also a chat box there, but make sure you put your questions in the Q&A so Sherrie and Maria will see them. And without further ado, I'm going to hand it over to Maria to start the presentation.
Good morning, everyone. Hope everybody's doing well this morning. I've already had my first cup of coffee, so if there are any of my coworkers watching this, I can already see them rolling their eyes because yes, it is caffeinated. So I may go right into Spanglish, but don't you worry, write your questions on the box and say, okay, I didn't understand a word Maria was saying. But as most of you probably know, I'm one of the partners at LSL CPAs, been here for 35 years, not a partner all that time, but yes, I started at 7 years old. As you guys, some of you may know, my expertise, part of it is the 401k plans. We are putting this webinar together for you to help you understand the new laws that are in effect of the retirement plans and to give you some information in reassurance. I just want to make sure that as you're listening through, it's not too late. If you're not doing some of the stuff that our beautiful Sherrie's going to be talking about, we are here to help you get through this. So just wanted to let you know that this is not to put you at a anxiety level. In fact, it's to help you know that you have support. That's the idea. Let me introduce Sherrie. What can I say about her? The reality is she's pretty darn wonderful. She's been my rock and support for the last 20 years. She just knows her stuff and there's no one better. So that should be enough to tell you how much I believe in her. But to get some more facts down, she does own her own practice, has been for 30 years an attorney. Her specialty is retirement plans, and that's qualified and non-qualified plans. And basically, I just go to her whenever I have any encounter, whether I have a client that's going to get a DOL audit, or I have just an error, or I'm looking at an audit and there's something. So basically, she's my go-to, and I hope for after this, she becomes your go-to.
Thank you, Maria. Thank you for that very sweet introduction. I feel the same about you. We have worked together, our two firms, from the very first day this firm was formed, and that was June 1, 1998, so 22 years ago this month. It's been a pleasure. Our firm, just very quickly, only practices in the area of employee benefits. I focus primarily on retirement plans, We also do, and I do, some executive comp and some welfare plan work. We're actually not going to cover welfare plans today, but there is a handout that has some more information. If you want welfare plan information, you can see that in the handout. It's a lot to cover in 1 hour just to get through the retirement plans. So that's going to be our focus today. This isn't legal advice, but we do provide legal advice if we're retained. So we're going to focus on the Families First Coronavirus Response Act and the CARES Act, Coronavirus Aid, Relief, and Economic Security Act. Most of the focus will be on 401k type plans. We will throw in a little bit about other types of retirement plans, including, just a few minutes on non-qualified plans. And I will say, this is a very dynamic area. The CARES Act in particular was enacted very quickly. And so there are many still unanswered questions, and IRS and Department of Labor guidance coming out weekly. We actually had to update these slides for a new 20-page notice that came out on Friday. And then we updated it again this morning for yet another little piece of guidance. So one thing that you very much can take away already from this presentation is very dynamic changes weekly. Make sure that, Maria, that they're getting your newsletter and they're signed up for your email alerts. You can also sign up for our newsletter. You can also sign up, for example, benefits link. But this is changing so quickly. If you're working with retirement plans right now, you just really have to have some system for staying up to date. Okay, so let's hop into what's the hot issue from last week and has been a hot issue since the CARES Act passed. The CARES Act really took retirement plans, which from the very beginning were designed to help people put money away and leave it in a plan until they reach retirement age. So many of the restrictions that apply to these plans are restrictions on you can't take the money until you terminate. You, in a pension plan, sometimes you can't take it till you reach retirement age. You can't take it just because you feel like taking it. And the CARES Act really just turns this on its head and turns what were intended to be retirement savings into basically emergency savings for people that are affected by COVID-19. So these new rules only apply to 401k, 403b, 457 plans. They don't apply to pension plans. If money's in a pension plan, this is not going to apply. That's important to know. They can be an in-service distribution or after termination distribution. And it's really at the employer's election whether they want to allow it in their plan. But participants can also choose, and employees can also choose to treat something as a COVID-19 distribution, and it also can affect IRAs. We will get into the details of how you qualify for one of these special distributions, and it must be taken in 2020. So it's a limited time unless that's further extended. All right, so who qualifies? Well, the original statute, the law that passed in March, said you had to be a participant or a spouse or dependent that was actually diagnosed with coronavirus, or they had some adverse financial effect folks. For example, if a participant was quarantined or laid off. There was a lot of confusion in the beginning. The IRS just, this was the guidance that came out on Friday, just expanded the class of participants that can take one of these distributions. So the new rules would include both the participant, their spouse, or any member of their household. And you can see my definition there. That includes anyone that shares their principal residence. So if you've got a group of 25-year-olds, 4 of them, they all share, and they're roommates, so their only relationship is roommates. As we read the new IRS guidance, if one of them is laid off or quarantined, they're all eligible. So you can see that that's a very broad standard. And the conditions are being quarantined, being furloughed. So that could be, for example, a temporary cessation of work, or actually your employment's terminated, you're laid off. Having your work hours reduced, or even if a job offer is rescinded or a start date is delayed, you can't get childcare because your childcare facility is not yet open. Your business has had to close, or you've had a reduction in pay. And so the 2 that are really new that participants had been asking for were my spouse has been laid off. I wasn't laid off, but we just lost the majority of our income. Prior to last week, that didn't qualify you. As of last week, it now qualifies you if your spouse has been laid off or had one of these other circumstances. The other thing that was broadened last week is a reduction in pay. So the statute said reduction in hours, but what happened is some employers, large law firms, for example, cut pay across the board. That, before last week, didn't qualify you. As of last week, that does qualify you. So as of last Friday, the number of participants who can qualify for one of these distributions has been broadened very significantly. And why do we care? Well, these are, from a tax standpoint, very favorable distributions. It can be up to $100,000, and that you have 3 years to repay it. So it's a distribution, technically, not a loan, but you can essentially do a 3-year rollover. You know, wait 3 years, pay it back, and then adjust your taxes to show that it was paid back. So essentially treated as a loan in that regard. Normally, if you're under age 59 and a half, there's a 10% early distribution penalty on distributions. That won't apply to these. Normally, if you get a lump sum distribution, you pay the tax all in that year. This can be spread over 3 years. And normally, a lump sum distribution is going to be subject to a 20% mandatory withholding if it doesn't go directly to an IRA. The 20% withholding rule also doesn't apply. So you can see these are very favorable types of distributions. Now, what are your action items? What do you have to do? And this is something I definitely want Maria's input on, because for plans that are audited, you need to be thinking now about, what do I need to do? What do I need to document? What is the auditor, what is Maria going to need next year when she's trying to do the audit for this plan? So number 1, make a decision. Number 2, get communication out to the participants about this if the plan is offering them. Some large record keepers sent out a notice early in March that said, if we don't hear from you in 24 hours, we're offering these to your plan. And so we've got a number of employers that didn't feel like they had a choice. They had a 24-hour choice. And they had sent communications out. Now the IRS has broadened it. Time to get communication pieces out again. The statute is clear that participants may self-certify their eligibility for these distributions. And the guidance that came out last week from the IRS clarified that employers, if they have what is referred to as actual knowledge that a participant is not eligible, they cannot approve that distribution. But there is no duty to inquire. So if a participant comes to the employer plan administrator and they sign that form saying, I'm eligible, it is not the employer's duty to try to question that in any way. And I personally, as a lawyer, think it would be hard and very rare that an employer would have actual knowledge that the person does not qualify, especially given how broad the circumstances now are to qualify. So if you think you have actual knowledge, before you say no, you might want to talk to counsel or an advisor. If an employer says, no, you can't have this, make sure you tell those employees, you have a right to appeal this. It's a denial of a claim. They have a right typically to appeal that under ERISA. You've got to go through that whole appeals process and let them prove whatever they think they need to do to prove it. The other thing to think about is this $100,000 limit. What we're seeing is that many of the large record keepers are putting the onus on the employer to police the $100,000 limit. So that's something that, if you have one plan and one participant, you will know if they hit $100,000. But if you have multiple plans, or if you are an employer in what's called a controlled or affiliated service group, that $100,000 limit applies across the controlled or affiliated service group. So if you have never done that analysis and you've thought something, there are many good reasons to do that analysis, but you just got one more, to make sure who are your related employers, because it will apply for the $100,000 limit. Maria, what do you think that you all, the auditors, will be looking for next year on this kind of documentation?
Thank you for asking, Sherrie. As you were going through it, I was trying to put it in little buckets. The first bucket for me would be, as the employer and the sponsor, figure out first, are you deciding to have anything offered to your participants? That's the first question. If you don't want to change anything and you don't want to offer it, just make sure your TPA hasn't done it for you without you even realizing it by sending out these things. That's the first thing. The next thing is you say, okay, well, now we do have some issues. I want to start offering some stuff. Honestly, is support, support, support. I'm going to need all of the documentation that you're sending them out, communication. Then we have to look at, okay, if you're going to do a distribution, I have to look at vesting. We have to look at forfeitures. We have to look at documentation for the qualification. We have to look at the plan amendments, the signed participant statements. So basically, once you turn on that oven to say, I want to do something, always be thinking every step of the way, I have to have documents, because you know how the IRS and Department of Labor are. If I have no documents, I didn't do it. So if I can't prove it, I didn't do it. I didn't do my due diligence. Just think about that for me every step of the way. If I choose not to do anything, you're good. But if I choose to do everything, document, 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 because I'll be bugging you.
Thank you. Yes, I think plan amendments technically won't be due for a couple of years, but what we are suggesting is when you go back to try to do a retroactive plan amendment, you have to know how to write the plan amendment. So you have to have some documentation of how the plan was operated over the next year in order to then write the amendment correctly. And then we've had some questions about, well, I'm being told I don't have to update my summary plan description until 210 days after the end of the plan year. Well, technically, that is correct. You don't have to update the summary plan description until 210 days after the end of the plan year. However, there is, in case law, the courts have held, there's a general fiduciary responsibility that applies anytime a participant has a decision to make. If you, the plan administrator, have information that any reasonable participant would want to make that decision, it is your duty to tell them about it. Here, if you're offering this, the participant has a choice to make whether to take this distribution or not take this distribution. That is why we are saying you must communicate now. You cannot wait until after the end of 2020. Their opportunity is gone. And the sooner the better, because participants are having to make decisions of, do I take the money from an IRA? Am I going to lose my house? If I had you can imagine how this goes. So this is not I can wait my normal amount of time and update communications later. They really have to be updated now. And no, you can't just tell the people that ask about it. So that's another question we had. So, well, we're just going to tell only the ones that ask. No, you've got to tell them all, or don't offer it. If you're going to offer it, as Maria said, you then certain steps have to be taken to properly implement this. Okay, the other change, and this is similar but not exactly the same, is that participant loans, the dollar amount has been increased from a maximum of 50 to 100,000, and the maximum account balance has been increased from 50% to 100%, and loan payments on existing loans can be extended. So again, this is optional with the employer, although I suppose if you're actually letting participants send in checks, which is rare, most of these are repaid through payroll deduction, then they may just stop paying, and you'll have to think about how that's going to get handled. Again, make a decision. If you're going to allow this, go ahead and communicate it and work with your advisors to make sure you get this implemented correctly. So if you've got participants who've been furloughed, they've been laid off, they can't pay their loans, there's a sort of a two-step process. If they have not actually terminated employment, once that loan goes into default, there's a deemed distribution. And if they terminate, so the loan's actually offset against their account balance, it's treated for tax purposes as an actual distribution. For these COVID-19 situations, a deemed distribution will not qualify as a COVID-19 special, all the special tax rules that we went through a few slides ago. But if it's an offset, if they've actually terminated employment and you've offset their account balance, they've taken their money out, it can count as a COVID-19 distribution. So complicated area, exactly how all of this gets done is laid out a little more detail in the notice that came out last week, how to handle these loan suspensions. Interest does still accrue, you have to re-amortize. So that's also, one of the big changes. And the other thing go ahead, Maria.
I want to make sure that I support what you're saying there, Sherrie. The important part that she says that even though, so let's say I'm a participant and I need the money, it's great to know that I'm going to have a little bit more. But number one, I got a couple of things. Number one, really pay attention that unless you really need it as a participant, don't take it. Because now your retirement, let's just go with the Social Security. It's not as if we're going to have a whole bunch of money waiting for us when we're 70 and a half. So the more money you take, the less you're going to be earning in your retirement funds. Number two is interest is accruing. So even though you don't have to pay. So this should be looked at in all intent and purposes as to, is this a necessity? I'm finding that sometimes people are seeing this because money is fungible, cash is fungible. So you could take the money and go put a pool in your house. But really think about doing that because it will bite you as a participant. So I just want to make sure that this doesn't become this chocolate ice cream that everybody says, oh my goodness, I have this option to do that. And I've always needed to do that. I need some freedom. I'm going to go do that. This is truly if you need it. It's all I really want to say. There are a dozen ways to Sunday to try to get money somewhere else. This should be your last resort. And that's all I have to say, because I know it's difficult when you've got 3 little children or 4 in college, which I had myself. It's very difficult not to use that money to do those kinds of things. But remember, you are going to be older, and your children may not be wealthy enough to take care of you. So you got to also take care of yourself. That's all I have to say.
Thank you. Good points. And the other thing I just want to mention is we are talking about changes in federal tax law. You really do need to talk to your tax advisors, such as Maria and LSL, because it is not clear yet how the states are going to handle all this. You know, there's state income tax. California typically follows federal law, but it doesn't follow federal tax law in every instance, and it remains to be seen. I haven't sat down with the 2 statutes. California incorporates a lot of federal by reference, and I actually haven't tried to analyze that yet. So just understand, whatever you're doing here on the federal side, you also need to analyze on the state side. And we may need some more guidance. And, you know, California may act to do something similar, but I haven't seen that yet. I don't think they've done it yet. All right, so there was some question about pension plans. For example, a money purchase pension plan, those are not eligible for all of these goodies that were offered to the 401k type plans. All right, with that, we're going to move on to another topic that has come up frequently in our practice in the last 3 months. And that is employers who need to limit or reduce costs, and they want to change the retirement plan contribution amount. This can, in some circumstances, be easily done. In other circumstances, it's not easily done. And it's another area where requests have been made by the industry and by some lobbyists to Congress to provide relief, to IRS to provide relief. Haven't seen it yet. Doesn't mean it isn't going to come out. IRS, actually, I have to give them some props here. They've done a great job of getting a lot of guidance out very quickly on a lot of tax law changes, but they only have so much bandwidth, and I haven't seen this yet. So the key here is, what does your plan document say? When does a benefit accrue? There can be a variety of ways and times that a participant accrues a benefit. It could be when they completed 1,000 hours of service, which I think on a 40-hour week is this week. So if you only have 1,000-hour standard and folks weren't part-time or out, they may have already accrued a benefit. It can be based on a payroll period to payroll period type of accrual, in which case you can amend it, but only as to future payroll periods. Some plans, many plans, require active employment on the last day of the plan year, which gives you some additional time to do amendments. And amendments are typically going to be required. If it's a defined benefit plan and you're going to cease accruing benefits, you have another whole set of rules to follow in terms of notices, particularly if you're a large employer. You've got to give advance notice of those. So this is a tricky area, but we are getting a lot of questions about it. For a 401k safe harbor, and many 401ks are safe harbors, mid-year changes to contribution formulas will typically cause loss of your safe harbor status. Then you'll have to do discrimination testing. Some employers who do non-elective safe harbor contributions gave what's called a maybe notice in December or before December 1 of 19. They typically can, with 30 days notice, change that safe harbor formula and go to a discrimination testing format. But important to note, because we've already had this question come up, we did that in April. Now we're looking at our numbers and we want to go back to safe harbor status. Well, that's a no. I mean, you might be able to do that during one payroll period, so it doesn't really affect anyone, but you can't opt in and opt out of safe harbor status during the plan year. If you qualify to opt out, you can opt out, but then you're kind of stuck for the rest of that plan year. Another option, if you didn't give a maybe notice, is again, if everyone in your related employer group is experiencing economic loss. Some employers are going to qualify for that. Again, you have to know who's in your controlled or affiliated service group. So I should include a handout on that for you all, because that is often an area where we get calls after the fact because there was an oops on that issue. So that's something you can proactively deal with right now, get that cleaned up if you haven't done that. And like I said, the IRS may offer relief in the future. Again, Maria, this is a question where if an employer is changing its contribution formula during the year, what are the auditors, what are you all going to need next year?
Well, thank you for asking, because the reality is that before we go making these changes, a couple of things you need to know. Safe harbor plans, that's where you, as long as you pay a certain percentage of your participants contribution, let's say 3%, as long as you're putting 3% for everybody at the end of the year, then you don't have to do any kind of calculations to figure out if some of the owners or people that make a lot more money than the rank and file would have to put money back. So before you make that kind of decision, it really has to be where you as an employer feel that you're experiencing an economic loss. Now, keep in mind, and I'm going to put a little bit of tax into this, but the PPPL, which is the loan that you can take. I'm going to read it to you. It says amounts, payroll costs, because as you guys know, the PPPL is, and we've done a lot of webinars on this, which Dave Myers and Mark Zimmerman have put up, which have done a fantastic job at it. It says that amounts paid for employer contributions to employee retirement plans, excluding any pre-tax or after-tax contributions by employers, will be included in your PPPL, which means that there's a huge potential that if you pay that dollar, that income that they give you, not income, but that money that you get from the PPPL will be not taxable. And this include payments for 2019 and 20, payments in 2020 plans. So as long as the employer contribution is not for deferrals, then any type of plan contribution would seem to qualify. So be very knowledgeable of that, because why wouldn't you pay $1 when you're getting that money from the government and it's not going to be taxable? So just keep that in mind before you make those kinds of really tough decisions. Oh, I'm not going to pay retirement plans. Now, granted, there's a whole bunch of limits, the $100,000, all of that, but just keep that in mind, because sometimes a retirement plan seems to be, well, I don't have to pay the profit sharing. Oh, I don't have to pay that. And you're right, you don't have to, especially if you're doing something that is allowed by the plan. But before you take that step, I really need the owners to really talk to their group to say, is this the smart thing to do? But let's say that you do decide that you're going to do it mid-year. Again, I sound like a broken record, but document, document, document. You're going to do it. You just have to make sure you document it. I don't know what else to say, because I can guarantee you I'm going to be looking at it. If I'm reviewing and I look at a payroll in September, and Jill and Sherrie are my participants, and lo and behold, I'm not putting a profit sharing plan or a safe harbor, I'm absolutely going to be asking you for it. So just always think about that. But before you take that step, there are just so many good things about making that payment that you'd have to really justify in your mind, and the only thing I can think of is truly, hey, I just can't afford it. And I get that. It is what it is. Let's say I'm in the retail business. I mean, those are the ones. I'm a distributor. I'm a manufacturer that just I have to. I get that. Just document it.
Thank you. Thank you, Maria. Another problem that we've been seeing with these amendments, if you're working with one of the larger record keepers, they have gotten very backed up on how fast they can turn around an amendment. So we were hearing 45 days, and that was 45 days ago.
Wow. I didn't even realize that.
Right. Which, if you're trying to get something in place, 45 days of additional benefits, that can cost you, some money. So what we have done is we sometimes can draft a board resolution and an amendment that can be signed immediately, then communicated to the participants. And then you take that to the record keeper and say, okay, we understand your document team's backed up. We kind of did this. Now we just need you to document it with a retroactive effective date. And keep this in mind now if you're planning to do something year end, because typically if you're with any kind of large record keeper, can be a 60-day period for them to turn around an amendment at year end. So you don't want to wait. If you are going to make this decision, you should be working with your tax advisor now, because it's almost July now. Make a decision in the next 60 to 90 days so that you have time to get these amendments done and communicated to participants, because you also need to give them notice. If, for example, you're ceasing a matching contribution, they need to be told, hey, we're ceasing the match. You may want to change your deferral. So that's just one more.
But I love that idea. See, as an auditor, if I see that you've had a plan, a minutes in a resolution that says, hey, we decided this and we're just waiting for our TPA, I'm good with that. In fact, that's wonderful. Just don't not have something and then you show your auditor that it happened 60 days later, because you're not going to be happy with the result. But that is a great answer, Sherrie, because this is something that they could, small employers are like me. We got to take action pretty quickly. Once we decide something, we got to move. We can't wait 60 days or we may be in the unemployment line ourselves. So
right. And
okay.
I do think your point about the PPP loans, now it's even more complicated, right? Because it went from 8 weeks to 24 weeks, but there's trade-offs for the 24 weeks. And so now if you have one of these loans and you're looking for the forgiveness, and why wouldn't you, then you do need to be talking to your advisors and planning out, should we be accruing this benefit for the retirement plan and getting the money, at least set aside, if not in, or are we going to wait till year end? How does that impact the loan forgiveness? Because it does. Those payroll cost calculations vary based on the 8-week or the 24-week. And so talk to LSL, talk to your advisors about the whole package. The retirement plan piece is just one piece of a big puzzle there.
I agree. Thank you.
So we talked about what to do on safe harbors. We've covered that. Let me just move on to, one other thing. Pay attention to how the 1,000 hours, if you have a 1,000-hour standard, you need to pay attention to your plan document. I know I sound like a broken record on plan documents, because different plans will credit paid leaves, they'll credit time off, they'll have possibly elapsed time and that sort of thing. So that's another thing. Okay, let me move along here on vesting. The other question that we are getting often today is, what if I've had a furlough? If I've furloughed 80% of my employees, did I have what's called a partial plan termination? And a partial plan termination requires full vesting of everyone. So Unfortunately, it's a facts or circumstances test. It's not there's no black or white, but a temporary furlough in and of itself will not automatically cause a partial plan termination. A layoff, if you laid off 80%, that could and probably does result in a partial plan termination. I'm sure, Maria, you're going to be looking at these issues next year. Was there a partial termination? Was everyone fully vested? If there was, is there some question about it? And I've given you here and your handouts, which you'll get, 2 articles that our firm's written that will go into much more detail about partial plan terminations. We might not get down in the weeds on it today, but many employers will be having. Go ahead, Maria.
I just want to say one thing on the partial termination. Truly, there is not really conclusive information. It may come out because this is going to be a pretty big subject by the end of the year, no doubt, because there's so many people that really had to do a lot of layoffs. But I'm sure that there will be. Right now there is not, but what it means to you, just so, because you say the term partial termination, you're like, what are they talking about? Well, what we're talking about is, if it should happen, basically means that all of the participants that had gotten laid off or whatever become automatically 100% vested. So we just want to let you know. So if, let's say, you're in a restaurant business and your vesting schedule doesn't reach 100% until you're in year 6, but you have this, you have Maria and Sherrie and Jill, which are your participants, and I've only been there a year, but you have a partial termination, I'm going to be 100% vested in the plan. So it's important that you understand why you don't want a partial termination. It's all I'm saying. It's not something that comes out of your mouth that easily. Partial plan, I can't even say it. Partial plan termination, but just wanted you to keep in touch of what that really means. I was just trying to say it in my layman terms.
Okay, thank you, Maria. One other point, if you have a defined benefit plan, you need to be checking in with your actuary. There is a delay on contribution funding requirements for defined benefit plans. If you're having cash flow issues, the actuary might be able to help you there. We talked about plan amendments. They really are not required until 2022, but keep a good record of what you've done, especially because Maria needs to document it next year.
I have a question, just a dumb one. Why 2022? Is that I know it has nothing to do with COVID, but I know that I would be sitting here as an HR manager. It's like, oh, I better write that down. What's going on in 2022?
I'm not sure what Congress's thinking was, but the good news is for most 401k plans, the IRS actually did just open up the 2-year restatement period, which would be April of 2022. And so I'm hoping that most of the document providers will get these amendments at least tacked on to that. They won't be approved yet, but they can tack it on so that you can one-stop shop and get your required, if you're on a prototype or a volume submitter document, that in the next 2 years, you're going to want to restate that plan anyway to keep your pre-approved status, that you'll be able to get these all done at the same time. So that might be one reason to wait a little bit. Even though that window, I understand some of the document providers are going to have their documents out this next month, July and August of 2020. You have 2 years to get it done. You might want to hold off so that they can get these amendments, at least some sort of snap-on model amendment that you can do it all at once. You don't have to go to your board twice or document it yet. So that's what we've got on plan amendments. Plan administration also has been widely affected, and there is guidance constantly coming out on this. Spousal consents, for example, that are required in pension plans. Many plans require notarized signatures. California, for example, does not allow remote notaries. And during March and April, you couldn't really see a notary in person. So the IRS just issued some guidance that temporarily allows use of the plan, a remote consent witnessing by the plan administrator. There are some hoops to jump through. And if you can do a remote notary in your state, the IRS will allow that. So you can look at that notice if you've got a need for spousal consents that are witnessed by a notary or plan representative. The markets are still fairly volatile. So if you are changing record keepers or for some other reason you are thinking about doing a blackout period where participants cannot get distributions or move investments, I think just think twice. We've seen several clients postpone blackout periods that had been planned for April when the markets kind of became crazy volatile in March, just because it's hard to give enough disclosures to feel like you warned participants when the market is up and down by 2,000 points in a day.
I'd like to make a comment on that. Sometimes
Sure.
blackout periods do hurt, because if the market does take a turn during that time period, the participants will be hurt. In the past, when the market has been so volatile, I mean, has not, even when it has been volatile, we wouldn't known until the day that the market said, oh my gosh, it went all the way at the bottom. But having this knowledge already, where there's volatility already, it probably would be really worthwhile for you to be thinking about maybe holding on until it gets a little bit more steady. Hopefully that makes sense, as compared to just like not knowing. How are you supposed to know when the market crashes? No clue. But in this instant, you're kind of getting a little bit more clue. So I agree with you, Sherrie. Think about it twice before making that kind of decision right at this very moment.
Right. I mean, in some cases it really can't be put off,
Yeah,
but it's a bit, it's a fiduciary decision, really.
I just want to make sure that we're all thinking about that. It just, all of a sudden when you brought it up, I'm like, oh my gosh, you're right.
Yeah, it was 2 weeks ago, the market dropped 1,800 points in a day. So, and it also had gone up that much in a day, a few weeks ago. So right now is just a challenging time to try to be doing that. Make sure if you're going to do that, you document from a fiduciary standpoint why you're making it, that you thought about it and you made a decision and you felt it was prudent, and here's why you thought it was prudent. That's the best thing you can do right now.
I love that. That's very important.
Then the other thing to look at is your definition of compensation. This is a common area where mistakes are made. But we've got people on all kinds of leaves, furloughs. Some people are getting medical pay. Things are just all over the place. But your plan document is still going to be your plan document. So you've got to pay attention to that, and whether a furlough is typically a furlough is typically temporary. It might trigger something under state law, but typically isn't going to trigger a distribution under retirement plan law. So pay attention to that too.
I want to make sure I say something on the compensation. This is an issue for plan sponsors. Even before this, if I were the controller, the HR, the partner that's in charge, I'm not kidding you, I would put that compensation part of that plan on my head, because it is by far the biggest issue that every single audit has. Things come up, And as an HR manager, you're there because your clients are your employees. The people you are loving and taking care of are your employees, are your participants. So when a participant said, oh, don't take money out for that one, oh, take money out for that one, your first instinct is you want to help. The reality, you wouldn't be an HR manager if you didn't have that part of your brain that's very empathetic. That's why it's so difficult to try to find a controller that has the head of an employee HR managers, because I think both of our brains work very differently. But keep this in mind, very important. You really will get a kick in the pants if you don't use because that would definitely be an error that you will have to pay. Because if you don't take a deferral, if you don't have an employer payment, whatever, you as a sponsor you got to put the money in. Even the employee money, Sherrie, what part of the employee money you have to put in case you miss it?
Right, it can be anywhere from 0 to 50%. So if you make the mistake, say just for the month of January, and participants have 11 months, you might be able to get away with 0. Or in some cases, auto-enrolled plans, you might get 25%. The standard is typically 50% of what they could have put in, not what they did put in, but what they could have put. So yes, compensation errors can be very expensive to fix, and sometimes just figuring out the fix, even if it's a small one, figuring out the fix can cost as much as the fix. Because
which is a great point that you bring in, because in 30 years that I've done this, the money itself that's going to the participant is minuscule. The loss of earnings are like literally less than $100, almost in every turn. But you have to remember, there is no materiality in 401ks. I tell this to people over and over, really, really think about it. I don't care if it's $1, 50 cents, or $200 million. There is no materiality. As compared, you're getting a financial statement audit, there is a materiality, and it's based on the number of assets that you have. This doesn't matter. You gotta fix literally $1, and it costs you $1,000. Crazy.
Yeah, no, I mean, sometimes, unfortunately, that is the case. I know we're starting to get a little bit close to our end time, so I want to just quickly mention one more thing on required minimum distributions. We talked about amendments, 5,500 deadlines for some have been extended, not for all yet, but elimination of required minimum distribution, again, this is a limited number of plans, not every plan, and some other guidance that came out just immediately extended the deadline to fix. So if it was January and you took your required minimum distribution and then you found out in March, oh, Congress just changed it, I didn't need to take it. Actually, it had to be February, but if you took it before you knew you didn't have to take it and you qualify, you can fix it through a rollover. IRS just extended that deadline for certain folks to August 31. So if you've got required minimum distributions and you didn't want to take, you found out, I really didn't want to do this, this is the time to talk to your CPA, your tax advisor, and get that, get a plan in place to fix that. Maria, any thoughts about that?
No, I'm good. You said it.
Okay. I'm going to just mention Section 409A, non-qualified plans. IRS just issued guidance on those, which allow some mid-year changes if an employee took a COVID-19 distribution. That was as of last week. Again, this is such a rapidly moving area. It's hard for benefits folks to keep up, let alone somebody who's HR and you're having to keep up with all of the other changes, COBRA, et cetera. But we're here to help you. Maria talked about the PPP loans. We covered that. So we're on to our question and answer. Jill, do we have questions that you want to share with us?
Yes, we do have one. Can you see that in the Q&A box from Tim?
Okay,
One
let's
just came in a bit ago.
Fidelity. Several participants worked with Fidelity, but we didn't have any interaction. How should we? Okay, so Fidelity is one of those record keepers.
Wait, can you, Sherrie, would you mind reading the question in its entirety?
Okay. Fidelity is our TPA and trustee. We are aware of several participants who work directly with Fidelity on withdrawing funds from their account. As the employer and plan sponsor, we had no interaction with these withdrawals. How should we respond with a broad communication regarding COVID-19 requirements for withdrawals?
Great question.
That's the question. And Fidelity is one of the record keepers that sent a notice, what's called a negative consent notice, email, short turnaround. I think it was 24 or 48 hours. They said, we are going to implement this unless we hear from you differently in the next 24 to 48 hours. So for this person who's in this situation where it appears that Fidelity just implemented this without any input from the employer, first I would talk to your Fidelity representative and find out, did they send you the notice? Did you not get it because of an email spam filter? So for some reason you didn't get it. I think for the employers that we've seen, they just may, especially because this was March, everybody was trying to move their employees to work from home, find toilet paper in the store. We all were just dealing with what was March of 2020. So I would first talk to your Fidelity representative and see what Fidelity has to say about it and whether they think there was a negative consent. If you really think there's an issue, the next thing to do is to look at your service agreement with Fidelity. So I'm just going to say one time, don't sign those service agreements unless a lawyer looks at it. Don't, because typically you agreed that Fidelity could do this in that service agreement because nobody looked at it and negotiated anything different. And then if in fact, you think after all of that you did implement it without really being aware of it, now's the time to get a communication out. And Fidelity should have standard communications. Make sure they update them for the guidance last week and get it out. That's that question.
That's what I was going to tell you, that when that happens and you didn't know, don't think that Fidelity is going to be responsible. You basically have to go in there and say, okay, now they did it. So now I got to go fix the broken plates. So now you're going to have to put out all of the information, get everything that you can from Fidelity, but it is your responsibility to start sending out all those notifications, figuring out, do I have to do a plan amendment or was it automatically because it was part of the service agreement? So unfortunately, a lot of TPAs, they say they're going to help you with a lot of things, but at the end of the day, you're responsible. That's the only thing I just ask. Make sure that you are ahead of the game and not after.
Right. And I think what we found for many of the large record keepers is they sent out the negative consent email. If they didn't hear back from the employer right away, they sent a notice. They at least put it on the website. And at that point, a representation was made to participants. Very hard to then walk that back. So you'll, I think, need to talk to your Fidelity rep. I mean, we obviously can get involved if there's a way that we can help. If, for example, you didn't get the negative consent, this isn't allowed under your service agreement, and communications didn't go out, maybe there's a path to stopping that train, but it's going to be tricky at this point since a couple people already took them. And then we would need to see, is that consistent with your plan document, et cetera.
It looks like we're right at the hour, ladies. So I wanted to thank all of you so much for attending. Remember to check your email later today because you're going to get a link to the recording, a link to download the slides, and lots of other free goodies from Maria and Sherrie, lots of nice content. So with that, I want to thank you all on behalf of LSL. We want to thank you and have a wonderful afternoon and we will see you soon. Take care now. Bye-bye.
Thanks,
Thank you, Sherrie.
Thanks, guys.